So this is part one of this series. The purpose of this series is to give the general public some more understanding of the process of a criminal case in Pennsylvania, how it starts, the stages that it goes through, and how it can possibly end. The purpose of this video is not to be legal advice. It's purely informational, general background knowledge. So if you are charged with a crime, cannot stress this enough, you should hire a criminal defense attorney or apply for an attorney at the public defender's office for the county in which you are currently accused of committing a crime. So without further ado, this is the anatomy of a criminal case. We're going to start with part one. How does a criminal case begin? And so we're here, we're at an arrest, and we want to look at what the first thing happens to begin a criminal case. 99% of the time, a criminal case starts with a police officer filing what's called a criminal complaint with the local magisterial district judge. That criminal complaint is going to include a number of items in it, but most notably it's going to include what's called an affidavit of probable cause, which explains to the local magistrate why the officer believes he has probable cause that the defendant committed a violation of a specific statute. So how does a criminal case begin? Okay. The criminal complaint, like I just described, is then filed with the local magistrate judge, also known as the MDJ, or sometimes just DJ. That's a local judge who basically only makes the determination as to what bail should be set in the case at the preliminary arraignment and whether or not there's probable cause to hold the charges in the court, into the court of common pleas. This judge, is not necessarily an attorney. Anybody can run for this office. More often than not, they're actually not attorneys and they have no formal legal training. Many of them are former police officers, depending upon what county that you're either practicing in or what county you're charged in. A lot of times you're going to see that their office is not at the county courthouse. It's actually somewhere local in the community. So usually the big county courthouse is in the county seat for the county that you're in. So for instance, in Berks County, the big courthouse would be in Reading. But if you were charged with a crime in Wernersville, your initial preliminary arraignment and preliminary hearing would be in front of the local magistrate who is in Wernersville. And a lot of times their office is basically just like in a strip mall next to a laundromat. Sometimes, kind of gives you some sort of sense of the formality of this stage of the proceedings. At this stage, we're still pretty informal as to what's happening with the case. So if a person is arrested as a result of the charges being filed against them, they'll go in front of a magistrate within 48 hours to have bail set in their case. Otherwise, they can be also issued a summons, meaning that they're not taken into custody by the police. They're given a date to show up in court to have bail set in the future. Usually, if that's the case, if the case is proceeding by a summons to start the case, you're probably not going to be taken into custody. They're probably not going to try to set bail on you unless there's some other significant factor that the court takes into consideration. So I want to show you a real criminal complaint, and this is a real one. This is one I found on the Attorney General's website. So that's a real defendant, William Higgins. You can look a little bit into his case. He was the district attorney in Bedford County before he got into some shenanigans and ended up getting charged with a number of offenses. But that's not what we're here for today. What I want to show you is basically the three main components of a criminal complaint. If you're an attorney, your clients are going to have documents that look similar to this. This is pretty much where every case starts as far as from a defense perspective. This is the first document you get before you get discovery, before you get dash cam footage, before you get DNA reports, all of that stuff. It all starts here. Filing of the criminal complaint. What is your client charged with? It's going to lay it all out here. So the first page, it's going to have the defendant's information, William Higgins, it's got their address. It has over here the magisterial district judge that the case is filed out of, and their address and phone number. It's going to have some biographical information about the defendant. It's going to have this right here, this OTN number. That's an important number. That's the offense tracking number. It usually starts with a letter. It's 6 numbers and a dash and another number. And then if you go down, you'll see that the affiant in this case, this case was charged by the Pennsylvania State Police, and the affiant, the person who is pretty much saying to the court on penalty of perjury that this is a true statement. So that's James Altenbaugh. You go down, you're going to see on the next page, what is the person actually charged with? What is the specific subsection of the crimes code the person violated? Here, as an example, this person, unfortunately, was charged with many offenses. More often than not, criminal complaint's not going to be this lengthy. But here he's charged with Section 5101 of Title 18, which is the PA Crimes Code. It's a misdemeanor of the second degree, one count of it. And it'll tell you here basically what the basic elements of that offense are. So he's charged with obstructing administration of law or other governmental function. If it's a DUI case you're handling, it would say driving under the influence of alcohol, and it would have in that on or about date the motorist was in actual physical control of a motor vehicle at a time when their ability to drive was impaired by the use of controlled substance. Up here you'll see inchoate offenses. If one of these is marked, that means that the offense is either an attempt, solicitation, or conspiracy, so keep an eye out for that. And then you want to go through and look at all of the counts that are charged against the individual, look at the grading, make a spread, make a little list of the elements that would have to be proven, because you're going to use this document and you're going to refer to it many times when you prepare for the preliminary hearing, because it's going to be the only document you really have as far as discovery is concerned, that and any other conversations you have with your client. So we're going to scroll through that. These are all the counts. Like I said, there's a lot in this one. When you get down here, the next section of the criminal complaint is the affidavit of probable cause. This one's a little different. Usually it says at the top, affidavit of probable cause. And basically the affidavit of probable cause is a narrative that the officer who made the arrest goes back to his office and he writes it down. And he says, here are the reasons why I believe we have probable cause to file charges against this defendant. And so you want to review that. You want to see, this is the beginning of, any sort of issue spotting. Do we have a bad stop here? Did they, get a statement that they should not have been able to get because it was in violation of Miranda or whatever the issues may be? They might not be relevant at the preliminary hearing, but you want to start thinking about this stuff as early as possible so you can start to develop a record that you'll be able to use at future court hearings. So we look at this. This one's also, like I said, it's very lengthy. This is a case of corruption in the district attorney's office of Bedford County. More often than not, on a routine sort of DUI possession type case, this is only going to be a page or two long. But it depends on the severity of the charges, the complexity of the case, the evidence against the individual. That's it. That's the criminal complaint. This is the document we talked about. This is what gets filed with the clerk, with the magisterial district judge, and also gets sent to you in the mail. It usually gets sent to you along with other paperwork. They basically explain it to you that you need to get an attorney, and this is the date and time you need to be in court for your preliminary hearing. So that's it. So come back for the next little webisode. We're going to be doing preliminary arraignments. Okay, the first time you're in front of a judge. That's all.